Hi everyone, this is Keith Pabian from Pabian Law. Today we're going to talk about a very important issue as it relates to H-2B visas. And that issue is whether workers are allowed to work in any other roles at an organization that sponsored them for H-2B visas. So the example we're going to use today is, let's pick a cook. So an organization sponsored someone for an H-2B cook role, and that cook now either wants to run food or they want to do a shift as a dishwasher for that organization. Now, this issue can come up in so many different ways, right? The organization, someone might have called out sick, the bus or runner may have called out sick, or maybe the dishwasher called out sick and someone just needs to fill in, and that cook raises his or her hand and says, I want to help. But for H-2B visas, that's not allowed. So what is allowed is the workers are only allowed to do the jobs that the organization sponsored them for. So that person can only work as a cook for the employer. Now, a lot of cook job descriptions have dishwashing duties in it, but they can't be stationed at the dishwashing position for an entire shift. They can't be clocked in as a dishwasher at any period of time. They can be a cook and they can go jump and help on the dishwasher from time to time, but their primary role and the only position that they can clock in for is for that cook role. Now, let's talk about the whys. Why is this rule there? Why is this a thing? And the reason is, it goes all the way back to, what did the government actually approve the employer and the worker to do? When you're going through the H-2B visa petition process, the first thing that we do, the first document that we do, is we create this job description. And that job description is the rules of the road, right? It lists the job title, the job duties, the pay, the benefits, whether gratuity is involved. It even lists the job location. And anything that deviates from that job description, which turns into what the prevailing wage is approved for, which turns into what the actual application is approved on, what's in the job order when we get to that stage, essentially the entire application is approved by the federal government for what that worker is allowed to do. And if anything deviates from that job description, then the person is working in an unauthorized job. So the question that a lot of organizations might ask is, how would the government ever know, right? They're still working for the organization that sponsored them. But the answer is that there's a lot of different ways they could know, right? If they're clocking in on a different shift, that's going to come up on paper. And we see that every year when we have to apply, because H-2Bs you have to apply for every year. And we can see if someone's doing something that they shouldn't be when we see the documents. But also we are in a time of very heavy enforcement measures. And when the government comes on site, especially in unannounced site visits that are completely random, one of the first questions they ask is, even for one shift, did you ever deviate from what you were allowed to do? And they are interviewing you as an organization, and they are interviewing the workers. So it is very easy for them to find out at this point, and they are finding out, and they know where the issues are. Now, in terms of consequences, there are big consequences for both the employer and for the worker. For the worker, if they are going outside of what they were approved to do, that is considered unauthorized employment, which could bar them from any visa opportunity in the future, could bar them from permanent residency, which is also a green card, and it could even end them up in a bad position with the federal government, up to and including deportation proceedings. But there's some real consequences there for the worker if they ever want to work and live in the United States again. For the employer, there's also really severe consequences, including fines. And one of the things that the government can now do is discretionarily deny H-2B visa petitions going forward for mistakes like these. So everybody, I know the temptation is there, right? H-2Bs are a seasonal visa petition, meaning that by nature, they're for organizations that are really, really busy at certain times of year, and you need all the help you can get. But it's really important to train your managers and supervisors and the workers themselves on what they're allowed to do and what they're not. And it all goes back to what's in that job description. If it's in the job description and if they are clocked in and working in the role that you sponsored them for, you have nothing to worry about. But if they're doing anything that deviates, you and that individual are risking really significant penalties. And we want to make sure that you're all set up for success. As always, we are here for any questions that you might have. You can find out more at www.pabianlaw.com. Thanks so much, everybody. Take care.